We're joined now by Lawson Naidoo, the Executive Secretary of the Council for the Advancement of the Constitution. Lawson, good evening to you. We've seen a lot of witnesses who've been giving testimony over the last few months against Busisiwe Mkhwebane. It would seem to me, considering the parade of testimony that's been brought against her, quite a tough job for her to now defend herself and refute some of that evidence.
Good afternoon, Stephen. Indeed, it is going to be a tough job because there's some very specific allegations leveled against Advocate Mkhwebane, specifically relating to some of the investigations she's conducted, the reports that she produced, which have been challenged in the courts and overturned by the courts. And not only that, Stephen, we will recall that there were some very harsh words said about her capacity and her conduct by those courts, including the Constitutional Court itself. She's been the subject of personal cost orders as a mechanism whereby the courts, which they use very, very rarely, used it against her to express their dissatisfaction with the conduct of such a senior public servant. So I think it's really about her being able to respond to that, the parliamentary committee, to consider the impact of those judgments and what those courts have said, and how that impacts on the issues before the committee, which is whether she is guilty of misconduct, incapacity, or incompetence, or a combination of all of those three.
Mkhwebane, and there's a sort of thread running through her testimony, that she hasn't been treated fairly by this committee, that she's been persecuted in some way, not just by people in the committee, but by people outside as well. How difficult is that to prove? I mean, she said it. Is she going to have to provide proof of that in this hearing?
Well, whether or not she does, Stephen, I don't think should have any real bearing on the issues before the committee, because the charges and allegations against her are very specific. It's about her conduct in various investigations where she was found seriously wanting by the courts. Whether she was persecuted, whether she has enemies amongst political parties, amongst other sectors of society. Casac itself, I believe, was mentioned by her by name as one of those organizations. But, we took up the case of the Frida Dairy Farm because it was quite clear that report was a sham, as it turns out to be, and that the beneficiaries of that project never really saw anything. So, that's what really she should have been focusing on. She failed to do that. The courts found against her, and this process in Parliament is really testing whether those judgments taken collectively constitute misconduct, incapacity, and incompetence on her part.
One of the points that Mkhwebane makes is that this committee is dominated by ANC MPs and DA MPs, and this sort of gets to the heart of it. I mean, it looks like we're watching almost a judicial process, a court process. There are advocates, there's a chair. We keep hearing about the law and how important that is. But the judges in this, or maybe the jury's a better example, are actually members of Parliament. So they will take, I presume, party instructions. I mean, this is quite a strange process, really.
It is. And I think, the fact that this has been turned into a quasi-judicial process is really at the behest of Mkhwebane and her legal team that have, insisted on this kind of process. I don't think it's an appropriate process for the purpose of the inquiry that the Constitution envisages. And just to make it absolutely clear, the role of this committee is to make a finding as to whether the public protector is guilty of misconduct, incapacity, or incompetence, make a recommendation to the National Assembly, and it is the National Assembly as a whole, comprising all of its 400 members, who will have to take a resolution with the support of at least 2/3 of its members before the head of a Chapter 9 institution can be removed from office. That is a very similar process to that which is followed in the case of a removal from office of a judge. In that case, there will need to be a finding to that effect from the Judicial Service Commission. But ultimately, the decision for the removal lies with the National Assembly. And the appointment of the public protector is done by Parliament, and therefore the removal ought to be done by Parliament. So, yes, it is an inherently political process because it is a parliamentary process. The members of the committee are not trained jurists, able to have a certain understanding of the law, but it's not a judicial process. It's an opportunity to give the public protector the right of reply, the right to answer to the charges that have been placed before the committee, and for the committee to then make up its mind. It does so on the basis they sit there as politicians. Whether they get party instructions or not, I suppose, will vary from party to party. But that is the nature of the process that is envisaged by the Constitution.
So she could, do everything correctly legally. The entire story could change. The panel could make a finding one way or another. And all of parliaments could then, like they did, dare I say, in the Pala inquiry, just go against that completely.
It's quite possible that that could happen because that is the nature of this process. It is, as I say, an inherently political one because it's a parliamentary one. But one would hope that this committee, this ad hoc committee that has been put in place, will look at the facts before it, look at the charges, the evidence used to back up those charges, the response from Busisiwe Mkhwebane, and then make a recommendation to the National Assembly on that basis. And as you rightly point out, they could recommend her removal from office, but the National Assembly could disagree and vote against that recommendation. So, that's the very nature of this process.
Lawson Naidoo, thank you, Executive Secretary at the Council for the Advancement of the South African Constitution. Really appreciate the time.